Hello, everyone, and welcome to Uncivil Law. And for today's story, we have the story of a Nigerian prince turned U.S. citizen who then decided to con a drug ring and became involved in a drug ring and is now facing serious criminal charges. You can't make this stuff up. The Nigerian scam is real, and the scam people today are both the U.S. government and the drug ring. This is United States of America versus Christopher Omigi, also known as Chief. In today's case, we're going to learn about Chief and his involvement as a Nigerian chief in the drug ring. Let's get started with this. From the early 2000s until 2013, Cesar Alvarez Barrera ran a Houston-based drug ring that imported large shipments of cocaine to Mexico. So Cesar over here for 13 years is running a Houston-based drug ring, and he needs some help. So this trafficking scheme brings fear of apprehension of law enforcement. You don't say. So in 2003, relatively early in this enterprise, because this began in the early 2000s, so in 2003, Barrera found a way to make himself feel better. He's afraid of law enforcement. He found a way to feel better, and the way to feel better came in the form of Chief Christopher Omigi. Omigi is a naturalized U.S. citizen, originally from Nigeria, where he claims to have been a chief or king. Bringing us to the Nigerian scam portion of this case, he held himself out to Barrera and other drug dealers as a person with supernatural powers that included the ability to divine the future and the ability to ward off law enforcement detection of criminal schemes. So the Nigerian chief says, I have supernatural powers, I can see the future, and I can ward off the law enforcement. And then the mastermind of this drug enterprise said, that sounds good. I want a piece of that. Wait, what? So this guy is running a drug enterprise, massive drug enterprise for 13 years. So, I mean, he's got to have some smarts of some variety. To be able to run a drug enterprise for 13 years sounds like it's going to take a little bit of work and effort. So you'd imagine you got a little bit of intelligence going on if you're this massive drug kingpin. And this guy comes to you and says, I'm from Nigeria. I'm a chief. I have supernatural powers. And the drug kingpin says, I want to work with you. Okay. All right. So Omigi, Omigi began working with Barrera, drug kingpin. And what services did he provide? I'm so happy you asked. He provided the services of supernatural protection for the drug ring, through such means as reading cards, cleansing conspirators with snake oil. He literally called it snake oil. He literally called it snake oil. He's cleansing the people in the conspiracy to make sure that they're pure. And the thing he's cleansing them with is a thing he literally is calling snake oil. He's from Nigeria. He's a chief. He'd like to cleanse the conspirators with snake oil, selling magic candles and cutting slits into the drug kingpin's skin with a razor. The drug kingpin who ran this criminal enterprise for 13 years out of Houston let this Nigerian chief with the snake oil carve things into his wrists. The drug kingpin also paid this guy, he paid for his periodic flights to Nigeria so he could repower his energy. I don't know what to tell you. I can't make this up. This is a thing that happened. Ultimately, the Nigerian chief's snake oil cutting powers were no match for federal authorities, you don't say, who began investigating the drug kingpin ring in the 2000s, making numerous controlled buys and recording incriminating phone calls among key players. In September of 2013, Omigi and 7 others were charged with conspiring to intend to distribute cocaine and conspiring to launder drugs. The indictment included a notice of forfeiture, which provided that should there be conviction, they would forfeit to the government $100 million, representing the amount of proceeds obtained as a result of the cocaine trafficking. Omegi's court-appointed counsel, so a negotiated plea sentence for 4 years. So Nigerian witch doctor chief snake oil guy over here is getting 4 years in the federal slammer, which sounds like a pretty good deal. However, it didn't sound that good to Chief because shortly after the plea, Omegi moved to substitute counsel. They granted the motion, and then they proceeded to go to trial. So his court-appointed counsel, because apparently he had court-appointed counsel from indigency or whatever, his court-appointed counsel got him 4 years in federal prison as part of the decade-long drug conspiracy. I don't know, man. Seems like a pretty good deal to me. Seems like a pretty good deal, but not good enough for the chief snake oil guy who says, I want to go to trial. I don't like the 4-year deal. Okay. That is an option, I suppose. The trial didn't last long. You don't say. The government's first witness was Barrera, the drug kingpin. Yeah. Who testified to the various measures that the chief had taken for the organization, as well as the role in the operation. The drug kingpin says, here's what he did. It's pretty good testimony. When the court broke for lunch, the witch doctor guy reversed course and decided to plead guilty. In exchange, the government moved to dismiss the money laundering. So they gave him a break. They're going to only hold him for the drugs. Following the plea, witch doctor friend was sentenced to 168 months, which last time I checked is quite a bit more than 48, which was the bottom of the range, to be followed by 5 years of supervised release, as if that is a thing that ever happened. Some people think court-appointed lawyers aren't really good, and sometimes they're not good, but so that can be said for private lawyers too. I have seen incompetent private lawyers and good private lawyers. I've seen incompetent government lawyers and good government lawyers. This government lawyer seemed like he was a pretty good 48 months. He said no. And then the government said, how about 168? And he's sad. He's sad at 168. He liked 48 very much. So he's gonna complain about this. So he has some objections. He contends the district court failed to admonish him of the minimum sentence, thereby rendering it involuntary, failed to observe certain prerequisites to the forfeiture, enhanced the sentence that he was the manager or supervisor of criminal activity, which, denied a downward adjustment for the acceptance of responsibility, and imposed a special condition of supervised reliefs that had not pronounced at sentencing. Nigerian chief's cocaine trafficking carries a mandatory minimum of 10 years. As the change of plea hearing, the district court stated the following: I must advise you of the mandatory minimum penalty provided by law, if any, and the maximum penalties that may be imposed. I have to advise you if there's a minimum, if it exists, and the maximum. I have to tell you what you're facing. If I accept your plea, you could be sentenced to a term of imprisonment of not less than 10 years, nor more than life. The Nigerian affirmed he understood the punishment that applied in this case. The record shows the Nigerian was repeatedly notified of the 10-year mandatory minimum attending to the cocaine charge. In short, the record made clear that he was aware of his sentencing exposure, and he pleaded guilty regardless of any error in the admonishment. Because maybe it was an error for him to say, if any. But no, because I have to advise you of a minimum, if any, because not every charge has a minimum. So I have to advise you of the minimum, if any, and the maximum. And if you plead guilty, I may sentence you to a term between 10 years and life. Indeed, the Nigerian does not argue otherwise. He asserts only a theoretical possibility he may not have understood the minimum. Okay, the assertion is inadequate to show that there was an error. The Nigerian's indictment also contained a forfeiture notice as required by law. The district court failed to comply with the remainder of the rule's requirements. So here the district court may have made a bad. So they did give you notice in the indictment. We want $100 million. They mentioned that part, but maybe the district court did some things because the indictment doesn't come from the district court, it comes from the attorney. It comes from the U.S. attorney. So maybe the district court screwed this up. So what did the district court not do? The court did not enter a preliminary order of forfeiture and did not address the forfeiture at the sentencing hearing. So he didn't deal with that part of it, despite the government having moved for the final order of forfeiture. So he just dealt with the prison term and didn't deal with that. In addition, the judgment did not mention forfeiture, and the final forfeiture order was not entered until a week after sentencing. So maybe this is a problem because the trial judge didn't mention it as part of the sentencing. The actual sentencing document itself didn't mention it. And then so after, here's your sentence. I may sentence you to this. Here's your sentence. I have sentenced you to this, and I'm not mentioning the forfeiture. And then there was an order that came by the way. So maybe that was a problem because he failed to give you notice. Okay, is it a problem? The court says no because you were on notice. The government wanted forfeiture. It was in the indictment. The indictment included this notice. The magistrate judge advised him at his initial appearance of this. So he mentioned it like when you made your first appearance. At the guilty plea, the Nigerian acknowledged he discussed the indictment with counsel and understood its contents. So he said he understood what he was being indicted. And he advised that he may, at that same hearing, so at the guilty plea, not at the sentencing, but during the guilty plea, the court did say that you may order you to forfeit certain property. So they didn't mention it in the sentencing, but they did mention it when you were pleading. We may want money. The government concedes that the first two prongs of plain error. So the government says there is a plain error analysis here, and the first two prongs do exist. The district court did fail to follow the rule, and that is, in fact, a clear and obvious error. There are three prongs, or there are three prongs to this test. Is there a rule, and did you clearly violate it? Clear and obvious error. So the government says the first two are correct. There is a clear rule, and the failure to do so was a clear and obvious error. But there's a third prong. Does it matter? The government contends that it doesn't show that it matters. We agree. No. To satisfy the third prong, you must demonstrate a reasonable probability that any forfeiture would have been less. So if they had done it right, would it have been less? So they screwed it up. But if they had done it right, would it have mattered? No. Therefore, no. You make no attempt to satisfy this, nor could you, in light of the uncontroverted testimony that he had paid him between $250,000 and $300,000. That was the testimony. So if the court had dotted its I's and crossed its T's, it would have given you exactly what it did. So yeah, the court screwed up, but it doesn't matter. Go away. The Nigerian next argues the district court erred in denying an adjustment for acceptance of responsibility. I said I was responsible. The guidelines provide for a 2 offense level downward adjustment if the defendant clearly demonstrates acceptance of responsibility. So the guidelines say you might want to give 2 levels down if they accept. The accompanying commentary, however, does take note that merely because you plead guilty does not mean you're entitled to this adjustment. So merely a plea of guilty is not enough. Other factors, including the timeliness, may outweigh the plea. The district court denied the adjustment primarily because he did not plead guilty until after, the extensive pretrial hearing and already after a half day of trial testimony. The half day was not going well. We have routinely upheld a denial of the reduction for acceptance when a defendant waits until the eve of a trial, and actually it's slightly worse than that. It's not even the eve of the trial. It's the day of the trial. In this case, it was in open court after the government had already started its case, and be like, what's the evidence against me? And he's like, The tactical move is more than enough to warrant this denial. Yeah, it wasn't exactly the most timely admission we've ever heard. How about no adjustment down for you? For the foregoing reasons, the Nigerian's conviction, custodial sentence, and forfeiture order are affirmed. Enjoy your extra 10 years in jail, and please give us $250,000. We remand for the district court for the limited purpose of ensuring the condition of supervised release is consistent with the oral pronouncement of sentencing. So you have to make sure, which presumably gives the district court an opportunity to cure this. So, that's fine. So that brings us to the end of the case of the Nigerian chief who ingratiated himself with a drug ring by saying, I have supernatural powers and I can see the future, and I'd like to cleanse members of the conspiracy with a substance I am literally going to call snakeoil. And the head of the drug ring bought it all. I don't know. But that's not really what brings us here exactly. It's that chief got an extra 10 years and he's sad. And the Court of Appeal says, no, you can be sad. You probably should have taken the deal. It was pretty good. Not really going to get any better. The government did give you discovery. It's not like they surprised you with this witness or something. Your lawyers knew what was happening. They kind of told you about it in advance, as they have to. It's Brady material. And he said, I want to go to trial. I'm like, oh, okay. And then at trial, half day later, you're like, oh no. And the court's like, and the government is amazingly less generous in its plea offer. How about we just dismiss the money laundering and just send you to the drugs? And he's sad. And I don't know. Just be comfortable with the sadness. There's really nothing left to be said. That brings us to the end of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.